As we are waiting for Yuliya Bondarenko, she's on her way here, so that we could start our presentations. We don't want to waste any more time. And it's my pleasure to welcome and greet you on behalf of the Association of In-House Counsels. This specific session will be discussing the present and the future of this profession. I see hands rising, but I think your questions should be postponed till later. But it looks like we will have a good discussion. I would like to draw attention to those questionnaires that we have prepared specifically for the purpose of this roundtable discussion. This is the fruits of the work and engagement of the most active members of our partnership, and we want to hear from you what you want from our partnership, what we can do to improve our work. I started the ball rolling by telling about this question, and I'm hoping that you will be able to fill it in. It's my pleasure to give the floor to Yuliya Bondarenko. She's head of the legal counsel at Rothmans, Benson Hedges in Canada. Dear colleagues, good afternoon. Let me brief you on the purpose of this meeting, about this unique opportunity to address issues that we are facing as legal counsels, what we are facing today, what we could expect tomorrow. I thought we have this very unique audience and panel, and we could cover all of the issues and questions you may have. I would like to start introductions. Yuliya Bondarenko, she's Deputy Minister of Justice of the Russian Federation. You all know Alexander Nesterenko, she's President of our partnership. David Leach, Group Vice President and General Counsel at Ford Motor Company. I hope you heard me before. Ruslan Ibragimov, Board Member Vice President for Corporate and Legal Matters at MTS. Igor Kondrashov, Director of the Legal Department at Sberbank, Russia. Igor Majdanik, Vice President, Legal Support at Rosneft. And Dietrich Neumann, Head of the Legal Affairs at Europol. To start our debates, I would ask for your leave to give me 10 minutes to reminisce about this association of in-house lawyers working on the topic of the profession, and annually, sometimes 2 times a year, and many of you attended the discussions that we had annually on the most pressing topics that in-house lawyers face. In particular, if you remember the history, and which unfortunately I can't show you on the screen, from 2009, our association started discussing the most specific professional issues back in 2009, if you remember, together with legal department heads at companies. We discussed the role of in-house lawyers. The year after that, we discussed KPIs and exchanged experience. In 2001, 11, sorry, we discussed leadership and whether there is any difference between leadership and expert knowledge. We followed that on with the changes due in the time of globalization, and then we also discussed how we should manage and administer our colleagues at legal departments, what should be the criteria, performance criteria, and finally last year we discussed the most recent developments in the profession and how we should combine compliance, GR, and legal risk management. And finally, we also discussed leadership from the point of view of the future of the legal profession. I wanted to comment on all of these topics very briefly. To do that, I consulted with the partnership's website. You members have access to this wonderful resource that combines all various presentations and contributions by your colleagues. I enjoyed very much looking through them. It was very difficult to choose any specific slides. Some of them are very insightful, humorous, but I made my selection of the slides that would reflect on the discussions we had. Now, if we are to remember what we discussed, looking at the role of in-house lawyers, the conclusions then, which are still relevant today, was that the lawyers were partners, not counsels per se. We agreed that the function is very important and that this is no longer a service function, that it was important to focus more on strategies, not on daily business, and we also agreed it was important for us to know more about business aspects of our corporate entities and the need to promote our function, promote our profession among our colleagues. I wanted to show you two slides, and those of you who attended these discussions, you'd remember the presentation by Rustam Ibramanian and his understanding of the role of in-house lawyers. And this is just a reminder what sort of discussions we had discussing the role of in-house lawyers. The next topic was the key performance indicators, or KPI. It's a very relevant topic still, and it took us quite a while to arrive at our understanding of the unique function, how we should proceed from cost center to value adding and value creation, how we could adjust our KPIs to be in line with the strategic mission of the company. The decision making was one of the key competence of our lawyers, how we should assess and manage legal risks. We talk about budgets and budget management, and we discussed various models of KPI. Just to remind you again, some rather humorous slides, and one of them was from Konstantin Kryzhevsky's presentation when we discussed the in-house counsel versus advisors. And another slide from Alexander Bakshin's presentation. Another topic was the leadership versus expert advice. We had a lot of feedback at the time how we should go about combining these two aspects, whether we could do that, and we agreed that some expert assessments as a unique rule is separate from the role of the in-house counsel, that it was also important to be acting as one, to be acting together, that comprehensive solutions should be sought after, and that it was also important to be able to inspire others and be a good communicator. And again, as a reminder, a few slides of the presentation of the CEO from Kraft Foods. It was his understanding, his take on the role of a good corporate lawyer, and a slide from my presentation as well on the right. The next topic was all about globalization and was happening in the legal at the legal department at the time of globalization, how we are made responsible for the comprehensive legal support. We discussed budget management, recruitment, promotion of our staff, and the leading role in preempting risks, and finally how we could make ourselves a key strategic function that contributes to value creation at the company. And again, a slide from Rustam Ibrahimov's presentation, which I think is very illustrative for the purpose. Two other topics I wanted to comment on. One has to do with the personnel management, which may be a bit new for lawyers, but it's something we have to face all the time. What sort of competences we need, what are the key challenges, particularly in the context of globalization, how we should retain and promote our people, what are the criteria of leadership, and also what we should do, what should we do to ensure stability and career promotion for our lawyers. And a few important slides, the Maslow's pyramid from Marina Abramova's presentation and Kvitko's presentation, covering a story of lawyers moving to another city. And finally, one of the most relevant topic is about the scope of the function, what sort of new professional and functional requirements are there, how should we combine compliance and legal risk management at every stage, what should be the appropriate model for the structuring of a legal function, and how we could contribute to management decision making. And again, two models, one taken from Tatiana Kuzmina's presentation and another one, again, MTS. And finally, the topic we commented on last year, and it had to do with leadership. It was actually all about leadership, what leadership qualities are required for lawyers.
And how can we deal with emotional, intellectual leadership, also the charismatic qualities, 5 levels of leadership. And there was a very interesting speaker, Alexander Mamut, who shared his views with everyone, and I got 2 quotes of Alexander Mamut and Tatiana Ugradelsova. Summing it all up, I would like to say, I believe that 5 or 6 years that passed, and when we looked at different aspects of the profession of in-house lawyer, today we can come to the following conclusion, that today the in-house counsels, they integrate strategy of the company. They make their legal experience a competitive edge of the company. They spend a lot of time helping to hire people, keep the necessary personnel. They use their legal talents as their contribution to the final result. And they're not just brilliant lawyers, but they are real businessmen with great experience in law. And they're real leaders, not just talented administrators. And that's how I would like to summarize that vision of the in-house counsels that we have. And regarding tomorrow, I would like to use lots of quotes regarding our life tomorrow, and I really like that quote by Abraham Lincoln: the best way to predict the future is to create the future. And this is when I would like to give the floor to our speakers, and I would like to start with David Lynch and ask David how these aspects of the activities of the lawyers, how are they significant for the creation of global legal department, legal service? So if you could share your views regarding the creation of the global service, so we would listen to you with great pleasure.
Thank you very much. The global, it's very interesting discussion of the topics that you have been through in the past, and I wish I had been here to hear them all because they sound very relevant, and I think I could have saved myself a lot of trouble in learning the lessons firsthand, hearing them from you and your group here. So very well done. I thank you for the invitation to be here and for the opportunity to both share some things with you and also to learn from the others. I'm sorry that I have to do this in English, but if I did it in Russian, it would be very, very short. So I have some things to tell you about the globalization from the perspective of the in-house counsel and the roles that you spoke of concerning being a business person and a partner and a leader. And I think thinking of the role in those terms, not just purely as somebody who gives expert advice in the law, helps one understand the global nature of what we do. It'd be very hard to be global if all you did was give advice on the local law. Instead, we do things that cut across the globe. We have to know the local law. We have to be able to give expert advice on law in jurisdictions where we practice. But we also have to do a lot more than that. So if I may, I'm going to take you through a few slides on what we do at Ford and hope that it's illustrative and maybe spurs some questions. So I know these are hard to see, but as I said, I'm going to talk about the skills that are required for lawyers across different jurisdictions, the role that we play in advancing the business, differences in the practice of law across different jurisdictions, and I'll touch a little bit on outside counsel and how we use them in different jurisdictions. Before I do that, just to give you a little perspective, because I think it's interesting to think about the company in which we practice, just to know the context in which all this takes place. Ford Motor Company, as you probably know, is a global automotive industry leader based in Michigan. We manufacture, distribute just about everywhere in the world. We have 183,000 employees. We have 65 plants where we assemble vehicles. We also provide financial services through a very large credit company which provides wholesale and consumer finance for both our dealers and our consumers. Last year we sold 6.3 million vehicles worldwide, slightly less than half of those in the US, and our revenue was about $147 billion. So pretty large enterprise to think about how you manage the global function. That enterprise has a rich history in Russia, which I thought would just be interesting to mention to you as well. We entered the Russian market in 1907 with a dealership right here in St. Petersburg. So we were in St. Petersburg more than 100 years ago. It's very interesting to think what St. Petersburg looked like at that time and what our industry looked like at that time. But Henry Ford was not bashful about trying to expand quickly around the world. We've been doing business in Argentina for more than 100 years. We've been doing business in the UK for more than 100 years. And obviously in Russia, we had a dealership here in 1907. We had a very interesting relationship with the Soviet Union. In 1929, we entered into an agreement where the Soviet Union would purchase automobiles and parts, and we helped provide technical assistance for a manufacturing plant in, I'm going to say this wrong, but it'll be translated properly, so Nizhny Novgorod, yep, which of course gave rise to this company, Gaz, that we had many American engineers and skilled workers coming over here to work in Gaz, which of course still exists today. In 1991, we established a dealership network again, and in 2002 inaugurated manufacturing in Russia again, right here outside of St. Petersburg, and we've sold 1 million vehicles in this market since we re-entered the market. Ford in Russia today, quickly, we have a joint venture, 50-50 joint venture we entered into in 2011 with Ford Solars, which is responsible for all of our business in Russia. And we have facilities still have the St. Petersburg facility and Tatarstan, where I was yesterday visiting those two facilities, and we have our headquarters in the Moscow region. We sold 100,000 vehicles in Russia last year. As you may know, the business is under some pressure thanks to a variety of factors, internal and external, but we're going to work through those as we always do. We have 12 lawyers in Russia, 5 in Moscow, 3 in St. Pete, and 4 in Tatarstan. So just with that background, let me tell you a little bit about how we think about our Office of General Counsel. We think of it as a global team. And our vision there, I'll read it to you since it's probably hard to see. We work together to deliver world-class legal, tax, and audit services to enable Ford to achieve sustainable automotive leadership in a compliant, ethical, and efficient manner. And there's a couple items in there that may be a little bit unusual. Tax and audit services. We have, as part of our Office of General Counsel, the Tax Counsel reports to me, and the general auditors, the internal audit function of the company reports to me, which is a bit unusual, but it provides some independence from the finance community, which is where most of the internal auditing takes place. And it's worked out very well, and our CFO, I think, actually appreciates it. So that's a bit unusual, but that's why we have that in our vision. We have 207 lawyers around the world, and as I say, we really emphasize working together as a global team. About half of those lawyers are in the U.S., and half of them are outside of the U.S. Half are in the U.S., not just because we're headquartered in the United States, but also because of the legal culture in the United States, which demands perhaps more in-house lawyers than other environments, thanks largely to litigation. Litigation is a very big part of our practice. We have thousands and thousands of cases pending against us at any one time, and we manage those in-house and work with outside counsel. We have what we call a matrix organization, which I'll demonstrate on the next page in a second, but we have people responsible regionally for various parts of the world, and we have people who are responsible for various subject matters, and they work together to make sure that in each part of the world, each subject matter expert is represented. And so we have both geographical and subject matter expertise covering each problem that comes up. We've also established, as a way for us to work better around the world, what we call centers of excellence, which are virtual centers where lawyers come together from around the world and work on projects, usually forward-looking projects that will be about what legal problems are coming toward us that we're not currently staffed for. For example, one thing that we're thinking a lot about is what are the legal issues related to the potential for autonomous vehicles, driverless cars, which Google and others are doing a lot of experimentation with. So we as an automotive company and us as a legal office are thinking ahead about what are the issues that will arise with respect to product liability, with respect to accidents, with respect to privacy, all those issues that might arise from this potential development, and try and stay one step ahead of those kinds of issues. So we have centers of excellence that are staffed from people around the world to bring different perspectives. You might have a Chinese lawyer, an Indian lawyer, a Russian lawyer, a French lawyer, a Brazilian lawyer, and an American lawyer working together to bring all of those perspectives and make sure that we're prepared for different legal regimes, because some move faster than others. In Europe is way ahead of the United States on privacy regulation. That's where most of the privacy regulation comes from. So we are led by our European colleagues. We don't have everything be led from Michigan just because we're headquartered in Michigan. We looked around the world where the expertise will be found and use that expertise. We have what we call biweekly business plan reviews and special attention reviews where we have a worldwide virtual meeting to conduct ourselves against key metrics. And we have worldwide training and development and lots of travel and lots of foreign assignments. We encourage foreign assignments among our lawyers. This is an interesting aspect of globalization. How can a lawyer from Cologne practice in Russia, which is our general counsel for Ford Solars for the last 3 years was a Ford lawyer from Russia, or from Cologne, sorry, here in Russia, trying to lead a legal team to integrate into the joint venture both the European and the Russian perspectives on the law. So the next slide is just this quick illustration of what we call the matrix organization. Most org charts that you see, or at least the ones that I'm familiar with, are pyramids. Somebody's at the top and then you get wider down at the bottom. We think of ourselves in this matrix organization where the people across the top have responsibility for geographic regions and the people down the side have responsibility for subject matters. So you'll see the head of litigation, the head of tax, the head of our intellectual property group, etc. So we work together, and each problem in the world should have a geographic person representing it and a subject matter expert. They may be one and the same, but they look at it from those two perspectives. We also have globally, worldwide, again, I know you can't read this, but this is a worldwide set of our strategic priorities. And I will just read across the top to tell you what the common themes are for our shared priorities. Number one, in the blue column there, is an inspired and effective global team. Again, the emphasis on globalization. The second one says zealously advocate and defend on behalf of our client. The third one is we effectively counsel clients. The fourth one is we effectively manage risk. The fifth one is we deliver financial results to our budget and to the company's bottom line. And the last one, is deliver innovative solutions. This is part of those centers of excellence where we try to think ahead and how we can innovate in future problems that are coming up. And we have a common set of responsibilities that we think work as well for that. So these are things we expect lawyers from around the world to be responsible for. In all regions, they're supposed to provide guidance to internal stakeholders in resolving complex legal and commercial issues. They're supposed to understand the developing nature of local laws and regulations and be adept in dealing with local issues, possess legal education and training in a mature market and local legal training and practical experience, high integrity and ethical standards, and courage to confront unethical and illegal behaviors. That's something that we emphasize a lot with our in-house lawyers, and have the ability to work with people from diverse cultural and social backgrounds. Obviously, if we're going to be a global organization, you have to be able to work in lots of different environments and work with people from different backgrounds and different legal regimes, different legal cultures. It's very important that we learn how to do that and respect what everybody brings to the table. Of course, we have to serve as a liaison between the local office, the regulators, and our external counsel. We have to understand the business and the products and our processes of our business. We're not just lawyers sort of free-floating in the business. We have to be deeply involved in it and really understand how the business works. So we spend a lot of time on things that might not seem directly legal, but they are helping us understand how the business works. In a complex business, it really helps if we give legal advice that's attached to the context in which we operate. And of course, we have to possess strong communication skills, and some of the lawyers speak multiple languages, present company accepted. So on the next slide, just what we do to advance the business. I've mentioned most of this, so I think I will skip over this to go to the next slide. Let's see here. There we go. I want to spend some time talking about even as we globalize, it's important to recognize that there are differences across the jurisdictions. And so we always have this tension between trying to act as one team giving unified advice to a global enterprise, but also recognizing that each individual lawyer operates in a jurisdiction and in an environment where the role of lawyers may not be the same as we might expect or understand. So I've listed here a number of the factors that can give rise to these differences. And let me just summarize some of these for you briefly, some of the things that I've seen as we operate across the different jurisdictions. One is education. You know, the legal education is very different in different countries. So in the U.S., a legal education is something that happens after your college education, and there's no sort of apprenticeship of any kind. Once you have your legal degree, you can go right into the practice of law. Other countries obviously have different approaches. Some learn law as part of your undergraduate education, and then you go into something like an apprenticeship. There are lots of different routes, and we have to recognize that new lawyers may have different levels of experience. And so, how a new lawyer is thought of in any individual context and what the experience level of lawyers is going to depend on where they enter the profession. Again, the role of the legal profession is different in different jurisdictions, in different business settings. In some places we have found, like the U.S., again, thanks largely to our legal culture, lawyers are pretty well recognized as being, very important to the enterprise. Good clients really want their lawyer with them. They understand the value that a good lawyer can play. Of course, it depends on having a good lawyer who's going to give you value. But in the best environment, we see a lawyer providing value and a client wanting that value to be brought to the table when business decisions are considered. In other cultures, some of this may be cultural, some of it may be personality-based, we see business clients who may resist having the lawyer at the table, may resist getting the advice of the lawyer early on in the process, and may want only to check the box at the end of a process and say, okay, I'm ready to act, somebody asked the lawyer if it's okay. Of course, at that point, if the lawyer were to say no, it would be very difficult because the business client has already decided what they want to do and they're just trying to check a box. We find that to be very troublesome, both for the client and also for the lawyer who's put in a very awkward position. So we try to educate our clients to bring the lawyers into the process early, but also the lawyers then to be problem solvers and partners with the business. But again, there are differences in culture in the way that different societies and jurisdictions accept that, and again, different business leaders have different perspectives on that as well. One thing that has been particularly an interest to me as I see different problems crop up around the world is what I've called here the certainty of legal regimes and enforcement. In some parts of the world, you know what a law is. A law is, what's written on the statute book or what a court has said the law is. In other parts of the world, that's just the beginning of the discussion. And, you have to, it's very hard for somebody from the U.S., for example, to understand how in some jurisdictions the law says X, but in practice something is actually quite different. And how do you know what it is? And so you can sit in the U.S. and insist on enforcement. Here's the law in X country, and I'm not going to name any countries, but in X country the law says X, and everybody agrees with that. But your lawyer on the ground is saying to you, look, I know that's what it says, but here's the way it works, and we're not breaking the law if we do this or do that. So, those kinds of cultural differences are very hard to navigate. So you have to have people in the field that you really trust to tell you whether you're in compliance or whether you're really skirting the law. And sometimes it's very hard to judge because the question is, what is the law in any individual jurisdiction? And I certainly did not expect to have to grapple with that question, but it does seem to me to come up more often than I would think. And we put a lot of trust in our local lawyers to act with integrity and ethics, but also to judge what really is the legal regime that applies to any particular decision that we might be making. Privilege issues are different around the world. In the United States, we have a pretty strong but perhaps eroding view of attorney-client privilege. Very different in the EU, and frankly, the role of lawyers in the EU, in-house lawyers, is perceived differently by the regulators in that they don't perceive the independence. There was just a ruling about German in-house lawyers' pension obligations that had to do with, I won't explain it in great deal, but it basically had to do with the question of, are they viewed as being independent or are they viewed as being captured by their client? And the regulators essentially said, we don't believe you're independent because you work for this client full time. And so the role of lawyers, the independence of lawyers, the privilege that lawyer-client communications might have or not have is also something that's very different around the world. Those are some of the factors. So I would just say that as we have a global team, we have to recognize that these things are different around the world. We have to communicate often and make sure that we respect each other's views. I think I've used all my time, so I will stop now and turn it back over. Thank you.
Большое спасибо, Дэвид.
Oh, thank you, David. Thank you very much. One question.
You mentioned about audit. You mentioned about audit being a part of your department. And this is really quite interesting and very unusual for me, even for American companies. Because normally you see that, how do you secure kind of division of powers, if I may? Because isn't like audit in your company have to check as well what lawyers are doing? Or do you, how is it perceived? And second question, is compliance as part of your department? Well,
yes.
It's the part of same,
yes.
If it's all inside of the same department, is it healthy enough?
Compliance and audit both report to me, but they're separate.
Yeah,
functions.
But you are not separate, you're the one.
I am one, yes, that's right.
How do you deal about that?
Well, I have a lot of things that report to me. Compliance and audit work very closely together where they can, but most of the audit function is auditing financial controls and processes. So the thought in our company was the audit, usually internal audit reports to the CFO, but if the role of internal audit is to audit financial controls and processes, reporting to the CFO is, it doesn't help their independence. So having them report to a senior official besides the CFO gives them a level of independence, and it's worked very well for us, and we haven't had any real issues with that.
Do you feel like you work for your management or the shareholders?
Well, it's always a good question. My duties go to the shareholders,
because
but
this
I
might
work
be
every day with
connected
the
with where
management.
the audit reports.
What's that?
It is connected where the audit reports.
Well, the audit ultimately, the audit reports to me administratively, but ultimately the auditor reports to the audit committee and the board, which represent the shareholders.
Спасибо большое.
Oh, thank you very much. And now I have a question to Igor Kondrashov. Igor, could you describe the centralized legal service of the major bank of Russia at the time where the bank was actively moving into the global market, the global arena?
Right. Good afternoon once again. I'm happy to see all of you here and to continue the discussion started by David. I can say that if Ford has been a global company for decades, for Sberbank, this experience is quite new. Over the past 3 years, we have made some acquisitions in Europe, in Switzerland, in Turkey, and even in Austrian bank with a network of banks in Eastern Europe, in Serbia, Croatia, and Slovenia. Bosnia and Herzegovina. I don't think many heard about Banja Luka, so it's quite exotic. Not many visited, but if it happens that you are there, then Sberbank is there. You can enjoy its services there in Banja Luka. I don't know how successful all this is going to be for you, but anyway, we're there. We're there. You can try, and I'll be happy to learn about your experience with that. Anyway, here on this map, you can see the presence of Sberbank. You can find America here, and that's because we have acquired Troika Dialogue company, and in the English and the American offices, we continue to develop the CIB business. And then the other jurisdictions I have already mentioned, so we are present in 20 countries, and including such exotic jurisdictions as mentioned above. Just for comparison, in the legal department of the bank worldwide, there are about 3,000 employees. Just for comparison, and after talking to the colleagues, I can say that the companies from the Magic Circle, Clifford Chance and Fresh and Stoltenberg and Claters, they would have about 2,500 lawyers all over the world. And Baker McKenzie has somewhat more than that. But if we try even harder, and if we ask for some additional funding and use outsourcing, then we can actually have a legal firm. And this is an idea that is of interest for me. I think it can be developed, although extra efforts are required, definitely.
So, of course, that would mean additional problems will have to struggle to perform up to our business plan. In any case, we have a lot of employees, and the two major tasks that we have to try to live up to in Russia are the centralization and optimization of various processes that we are involved in, and on the other hand, trying to achieve the maximum capabilities, the maximum performance out of all the existing structures of Sberbank across the world. In Russia, Sberbank tries hard to form and generate the risk management system to minimize risks and potential losses. In other countries, such as Turkey, things run differently. So when we face problems there, then we see new challenges. For example, the largest deals that our Turkish department has to approve, and when we hear about these deals at our committee, the Turkish lawyers presented the case. They told us, usually, this is the company such and such, the largest tourist company in the Turkish market, established in 1924. Very respectful people, very respected people, and the financials were secondary, because you cannot but trust these respected people. Or they say, this is the company that belongs to the majority party in Turkey, and you can't refuse these people money. So we were forced to act differently, and our legal processes were, in a way, adapted to the realities of the market. we had to try hard to make sure that our colleagues are brought on to the other side. Right now we try to focus on new management methods, and I would like to debate here a little bit. I'm sure that some of these issues will be covered in detail later, but let me just say that we believe that we have a different position on whether or not lawyers have to be in the focus of all activities. We try to differentiate between compliance, due diligence, various controlling functions. It may be in the same department, but there are definite borders between different activities. And Mrs. Latko was a very well-known person in this area. She wrote to me that there are a lot of difficulties there, but of course when a person of that scale is in charge of the department, things run a little smoother, a little more smoothly. But I believe that legal professionals should do their lawyering, but of course we are involved in all the processes that I mentioned earlier. In any case, the management model that you can see on this slide is the dot line basis that we follow. So the heads of legal services of Sberbanks, the heads of legal services of our affiliates and the legal services of our offices abroad do not directly report to me. So we manage the risks. And the structural regulation, the budgets, motivation is within our purview. And this may not be something that our colleagues from legal firms like. While I was in charge of the legal service of Sberbank, over the past 3 years we cut our outsourcing costs. Well, the department that you are looking at is the lawyer management department. We manage our lawyers in such a way so that they were integrated into a single, well-structured system. Because we have affiliates abroad, our lawyers there have a lot of experience, and their experience was accumulated in different ways. But everything is organized in such a way, and let me find a slide that would support this idea. Maybe a little bit more difficult to read, but nevertheless this slide demonstrates the structure of our service, the head office, our affiliates in different territories, in different cities. We try to centralize a lot of functions as much as possible. The international law, financial markets, all of these functions have been centralized. They go via Moscow, but the local Sberbank legal services are left with the functions that need to be resolved at a local level. Court representation, corporate business support. So in the past 2 years we were able to cut our legal service. We had to leave, we had 200 lawyers that had to go. And 2 years ago we found ourselves in a very strange situation whereby we had to audit our own processes in different areas. And often the time needed for lawyers to perform similar legal services was very different. In some cases, the difference was up to 10 times longer. So we try to optimize the number of lawyers, we try to optimize the processes. We did it mostly through the business project management system. We have a new computer-based system to manage legal services, and most of our legal services today are managed with the help of this computer-based system. That helps us to optimize our efforts. And now, as far as it concerns the in-house lawyers, Sberbank is definitely one of the largest players in the Russian market and in Eastern Europe as well. 2 years ago, we were in the 14th place in the world in terms of capitalization, but because the ruble is not as strong as it was 2 years ago, we are losing this position. Nevertheless, if you look at the private clients, individual clients' loans, we have 45%, corporate clients' loans 45%. The share is growing, and our lawyers face new challenges. The requirements to their qualifications are growing. New structured deals are implemented in the financial markets, and our lawyers have to support those deals that are made by our affiliates. So they have to be experts in various laws, in the law of Croatia, in the Turkish law, at least in its basic concepts. At this point in time, we can see that there is an overall trend of a greater role of government, a greater role of the state in private business. So I believe that a similar trend can be seen in law, in the legal profession, and we will always welcome new lawyers among our ranks. Thank you very much, Igor. I can see that we have a lot of hands in the air. Let's leave the questions until the end, but one question can be taken now. One question to Igor, please. I have a very simple question. There are two very extreme examples that were given here, two extremes. Do you think that decentralized structures is the reason, is the result of so many lawyers? And do you think that decentralization is the only possible way to manage so many lawyers? Do you think it would be possible to find an optimal structure in a decentralized way? And a mini follow-up question. What metrics do you use in order to understand and assess what structure would be the optimal one? Do you have any benchmarks? Number of lawyers per number of other employees? Yes, we use all kinds of benchmarks. Number of deals, the number of processes per lawyer. Right now, I think, based on the system that we have, I forgot to tell you that in Russia alone we had 260,000 cases, court cases. It's not the main function of our lawyers, but whenever a case is taken to court, it's usually is related to those clients who did not pay off their loans. So they are typical cases. The questions are not spoken into the mic. No, our benchmarks are not tied to the profits. As to the optimal model, as I said, Our task right now is to somewhat centralize the functions in Sberbank and try to take the lawyers out of the small local affiliates. But that is not always possible. In some cases, as in the faraway regions, it takes people several days to reach the closest court. They have to take a boat and then they travel by reindeer, etc. The speakers are not using the mic. Yes, sometimes we have to participate in that. Our judges are not always prepared to use documents that are being sent by mail. So as I said, the audit that was performed in our affiliates abroad demonstrated that we still need to put in some effort in order to adapt our affiliates to the Russian standards. It may sound a bit ironic that we want to change the ways in an Austrian bank so that they matched the Russian standards, yet this is true, and our task is to see the system unified by 2015. Thank you for your questions. Thank you, Igor. We are very excited that we have such a lively discussion, but I would like to change the area of our discussion somewhat. I'd like to ask Irina, at this point in time, we may probably draw some preliminary conclusions. From the point of the Ministry of Justice, do you see any special role for an in-house lawyer in general? Do you think that this special role should be reflected in the professional education and professional development of such a lawyer?
I would like to start with the words of thanks for the invitation, and thank you very much for your question. I feel myself very strange, like donning a few hats at the same time. Before the break, I was at one of the sessions that's where defense lawyers were dominant. I used to be a defense lawyer myself, but I also was an in-house counsel, and I know very well what this profession involves and the issues that they're discussing. All these issues are personally very close to my heart, and some of the models that we've been have been discussing here, they may be extreme, like I had the discussion before lunch about closed and open markets, the same as here. They may have very close-knit units with teams covering all aspects of legal risks. I personally believe that most of the compliance risks should be covered by lawyers. This is part of the legal profession, and this is the position that we defended at the Justice Ministry when we were working at the technical requirements. We used to have separate experts vetting of various legal drafts from the government, but we managed to insist that there shouldn't be a separate anti-corruption vetting, and this is one of the risks. This is part of legal risks. So I'm very much in favor of this kind of integrated approach. But on the other hand, a large corporation, particularly a multinational corporation, is almost a separate jurisdiction, a state of its own, with its own governance, its own structuring, all down to their specific business mission. So there is not one single perfect recipe. So another extreme would be to try and take into account the specific processes in each corporate entity, as well as certain administrative and other patterns of environment in which the company functions. I have enjoyed our discussion so far very much. Now down to your question about the role of the Ministry of Justice. I'm as deputy of the Ministry of Justice. I'm responsible for regulation of the legal profession in all its complexity, including notaries and defense lawyers, and whether we at the Ministry of Justice see something specific and unique that should extend to in-house counsel. For us, in-house lawyers are our very true partners. We seem to share interests because in-house lawyers want to have transparent governing law, predictable law enforcement. The in-house lawyer would want to see prepared, highly competent professionals. Corporations tend to outsource some of their legal procedures to, depending on the specific circumstances. If they need some very narrow experts' knowledge, so willy-nilly they would bring in advice from outside anyway. So as partners in our effort to monitor law enforcement we are very much interested to have a sound legal protection profession. It starts with good education, and we have just heard that we all want to see the best of the best, but the same is true as far as other legal firms are concerned. And in that respect, you compete with many other corporations and legal firms for the cream of the cream, the best of the best of the future professional. So the better the legal education is, the more highly competent lawyers we get, the best the position is for you to enjoy, and we are benefiting from it as well. As to the way legal departments should be structured, companies could be large and small, they could be unique, they could be more or less common, and of course, in some companies, lawyers may be the last instance to address unsolvable or unsolved issues. For many in the company, lawyers may be the worst of evils, someone who must have but hadn't signed or visited the documents, and hence conflicts increase, and of course the government is not interested in seeing more conflicts, multiplying conflicts. Lawyers are the ones to help promote a conflict-less regulation. Their mission is to prevent or preempt conflicts, whether this is public or private law, where the law is strong, when attitudes are that of respect, the risk of conflict is diminished. Depending on how companies treat the position of their in-house lawyer has direct implication and effects on the stability of trades, on the volume of trade, and so on and so forth. So we're extremely interested in seeing the profession, your profession, getting stronger, and the standards of your profession getting healthier. How it could happen? There are lots of companies, mostly larger companies, medium companies, smaller companies, usually not too big enough for that, where top managers may realize that correct assessment of legal risks covering the entire gamut of risks could have a direct economic effect. In those companies where that has happened, lawyers tend to get a slightly different position, which may be another extreme, and this may not always be a good thing. I remember my very first job was at a defense factory, and I had one of those red directors, although he used to talk about accountants, but I always translated onto the in-house lawyers as well. If the factory can survive without accountant's office, this is a gang. But when accountants rule the factory, this is not a factory but an accounting office. And this is, of course, the same, as much true about the legal profession. So the proper structuring of all legal aspects in support of business is important, and this voice should be heard. The voice of the law should be heard. But on the other side, on the other hand, if there is this bias towards risks that lawyers may point to, and the governance structure is such where the lawyers have too much to say, and their advice as to the risks is taken too directly. No deals will be completed. And this is another extreme. As for the advisors, their mission is to cover whatever he sees, and he's not particularly interested in what will be happening after that. For in-house lawyers, it is important to promote the business of their company. Of course, they will be suggesting possible risks, but they would always come up with mitigation, ways to mitigate. If it is the way lawyers see their position, their function, if the business as a result is sound, the government will benefit as well, because it would spell sound economy, good taxes, and so on and so forth. Now, again, back to regulation, and again, before lunch we had this very serious discussions about Russian legal profession, which is open probably as nowhere in the world. It is open to outside, whereby foreign advisors have free access to domestic markets, but it is also open to all other spheres, with exception of the criminal defense lawyers. So as a result, we see a whole list of various issues we need to address. In-house lawyers, of course, almost always have the university degree, and when they are retained, even at smaller companies, they would ask for diplomas of university degree. While if you're just doing advising, this is not a requirement that you would have to comply with. But apparently, if we have certain requirements to the legal profession, we don't believe that legal profession in-house lawyers should be regulated very specifically. It's up to the top management. As for the access, of course, and it's an important issue, whether in-house lawyers could have access to courts. And you would remember there's a whole history behind that when there have been when changes were introduced to the economic court's procedures. Two classes of legal profession were allowed, defense lawyers and in-house counsels. This was a landmark decision, and before that, corporate law, they were corporate lawyers for one night that were retained by the company for the litigation purposes. They were not proper in-house counsels, but they were allowed to represent the company. I would argue that in-house lawyers should be allowed to litigate in court because they have very good knowledge, thorough knowledge of the company. They have good knowledge of argumenting their position, and on the other hand, it's all down to their competence, their qualifications. There should be some standards, and by the way, it's not clear who should promote or promulgate the standards. I'm having rather high hopes as far as your partnership is concerned. By increasing your membership, you may one day come up with some suggestions what standard should be like, so that we could mitigate the risks of unqualified representation in court. These risks are very much material today. At the same time, we see certain issues that in-house lawyers themselves are facing, and sometimes they do not disclose this type of hazards or risks to the top management. Defense lawyers have certain privileges. They have the status. They have the They enjoy the protection, particularly as far as criminal proceedings is concerned. When you do your due diligence transactions, when you develop and structure the the advising lawyer has to observe confidentiality, while in-house counsels could be interrogated and they have the obligation to disclose everything they know. You should be aware of that, and the work of your department should be structured in this way so that you could be fully aware of your personal risks. Overall, and this is quite often, quite frequently happening today, and it's actually quite common, where lawyers do both leadership position and they become parts of the governance structure, and of course this leads to the subsidiary liability into many other risks involving criminal.
Well, I don't think that we should change anything, but we should understand it really well, and we should, and the association can outline some criteria, some understanding, maybe some recommendations for the members how to arrange it the right way. Did I answer your question? Yes, I think you answered the question. Yes, definitely. I would like to apologize right away. Well, first of all, I was late, and also, well, I am the person who is responsible for organizing the whole event, but I cannot stay here till the very end. If you have any questions, I will answer with great pleasure, but I do have to go really soon. Any questions? If you have questions, maybe after she answers, we'll let you go. I told you everything, so you have no questions left, right? My question is, I'm sorry, I'm from Moscow State Law University, and I'm sure that some graduates of our school are here. And what do you mean by the best graduate of a law school? What should we teach them? Is this the person who is capable of thinking, analyzing, or the person who knows all the laws by heart? That was the first part of my question. The second part is what are the best forms of interaction of business, in-house counsel, and education? And our students are your future. Our graduates will come to you, will work with you. Our biggest problem today now is the fact that our graduates don't have practical skills. Practical activities are not really connected with education. Please help us, and we'll help you. Yes, well, I might stay here forever with such a question. And I will take time from other speakers. Well, tomorrow I'm sure that we're going to discuss it at the conference dedicated to legal education, which is going to be conducted right here. But I will tell you in brief what I think about in-house counsel. Well, the first thing that we all, the employers, are interested in, what would like to have for the graduates regarding, well, we would like to receive a normal, sensible person, capable person who can treat this world in a very sensible fashion. Unfortunately, today it's not so. And when I conduct job interviews, most often professional questions are out of the picture, because first we try to test reasonable skills, analytical skills, very simple human skills, and the person cannot communicate properly, cannot be social enough. So this is our first requirement, to have a normal, sensible person. Yes, a lawyer, definitely a lawyer, but from the point of view of hiring a lawyer. Secondly, our eternal problem of the balance of theory and practice. And I was present at the procedure of certification of Harvard Law School, which is conducted by the ABA, I believe, and some kind of accreditation, certification procedures going on. And they had a very broad discussion. What's more important, practical skills or theory? And having listened to them and having analyzed what happened in our country in the course of 20 years, I came to the following conclusion. Soviet school was really strong in theory, and that was a very strong theoretical school that provided certain foundation that there was no legal writing course, no legal speech course or whatever, but at the same time, in a very short period of time, that foundation could be properly used to get practical skills that provided for brilliant career. And here the first problem that I mentioned, how sensible the person is, well, there was no such problem, because while young people learned theory, somehow everything was organized in a very structural way. And then a number of hours time training. Well, the theory foundation is much less, but nobody could provide serious training regarding practical skills. And as the result, well, some graduates are brilliant, I'm not talking about those, but we have, in general, we have lower quality of our graduates. They are not ready to work practically right away, but they don't also have a good theory foundation. they know a lot of buzzwords, fashionable, technological things, but they don't understand what the legal relationship is all about. They like for the musicians, you don't differentiate between the piano and the concert piano. And now our educational system, system of legal education, is looking at possible paths to follow. Well, on the one hand, to have legal clinics, to be able to read documents, to compile necessary documents is highly important, but it's also extremely important to have some fundamentals, some basics of the law, at least during the first years of their studies, because quite often when you deal with somebody who graduated from the School of Mathematics, and this mathematician, young mathematician, is much better than a law school graduate, much more logical. But I hope that tomorrow at the conference you'll be able to discuss it all. Well, thank you for your answer. Thank you for recognizing the importance of theory, of course, combined with practice. I do hope that practitioners would come to us. Maybe they will arrange master classes for us. It's important for students. Thank you so much. Thank you. Thank you. Well, taking in consideration the fact that we touched upon the issues of corporate management, I would like corporate governance. I would like to ask Igor Maidanik, so what are your views regarding the legal department and the system of the legal department? Thank you for this opportunity. But first, I would like to continue our discussion that we just started. And in the context of the question just asked, I realized one thing. All the panels, all the discussions here at the forum, they are legal. They are very specific. And the only panel year after year, this is our panel, which could be called the management, the governance of legal profession. And today we're discussing the functional part of the legal, also just creating the units inside the legal service. And unfortunately, we have to state that today we don't have managers of legal profession. We could talk about in-house lawyers, we could talk about organization of legal services in law firms, but there is no real management of legal profession. And I believe that with a priority that should be given to legal education, we should have this course in law school, because sooner or later you have to manage the work of lawyers inside the company or inside a law firm. And today we don't have enough such experts. And also we have very basic legislation regarding partnership in law firms. It's not mine. I've always been an in-house counsel, but when we're looking at the structure of law firms, in our legislation, we don't have proper regulations for the relations of the partners, of the associates. We don't have enough legal basis. But I would like to share my experience of structuring the legal service. And I would like to tell you about the history of this matter, what started in the mid-1990s and what we have now. And in the middle of 1990s, the functional part of the legal service is determined by the strategy of the company. First of all, by the strategy of the company, which was quite topical in the beginning. of the forming of the free market economy, and then we're talking about somewhat different priorities. We're talking about business processes inside the company, and legal service is usually following the economic units and the 1990 end of the 1990s. And I was lucky. I came to the company without any legal service as such. There were some separate lawyers working in different departments, and I had to get them all together. And I had to develop certain principles of getting them together. And the first thing I thought about, and that model existed for a while, is creating these units using the principle of professional specialization. And of course, we all studied just in accordance with the classic principles, civil law, criminal law, procedure, and our first experience was to create our legal service, just dividing people in accordance with their specialty. So we had the contracts work, also claims, then expert assessments, and our legislation was not really stable at that time. It was really volatile. And in the course of 1 week, we witnessed changes in just currency law, tax law, all types of law, and we had to follow the situation. We had a very strange unit. It used to be called M&A. That now at that time it was more of a hostile takeover unit.
So these days it's M&A. Anyway, it's a corporate model, but it existed for a while, actually, for quite a while, and there was no criticism of it, because they developed together with the company. There were close links within the company. We all knew each other, and there was no conflict as such between the lawyers and business. But then the year 2003 comes, and a new shareholder appeared, the BP company, with a very different culture, with a different understanding of how business processes should be built and run, with a very different relationship between the support services and business. And without any close personal relations. So the communication issue became quite urgent, and the company began to think about that. Well, of course, any business with taxation wants to have its own counsel, and so the problem of the single window emerges, and the business in its new hypothesis needs this sort of explanation, why there is this specialization. No, whether you're upstream or downstream, you have to come here. So anyway, we really had to build it following the customer's principles. And initially the model worked, and everybody was happy, business was happy, they knew whom to communicate with, they knew their counsel, but it was not enough, because the total control of legal costs is there, and there is no access to the top managers, and it's impossible to take a decision without the lawyers. And so we would like to have our own lawyers in upstream and downstream divisions. And so that was the situation. Like, we did not agree to that, and we were assisted at that time by the crisis of the year 2008, because the consulting expenses had to be cut, and were afraid of consulting turning into something uncontrollable. Only we, the lawyers, we kept saying, could actually keep everything in rein. So this model did not develop. The next model is the model that today can be found in the global oil companies. Here it is. The counsels within the business in-house, and then there is also an independent center. So that means every upstream division has its own lawyers, downstream divisions have their own lawyers, the support services have their own lawyers, and in the corporate center, in the head office, there are also counsels responsible for the methodology, similar to what we can see at Sberbank in a way. And this model exists in ExxonMobil, in BP, and other companies. So we at Rosneft are ready to accept this model. Mentally we're ready, but we do understand that this model is going to work only if the business division is self-sufficient. It's not just part of the corporation, but has its own reporting system, and they control their own expenses, so it's actually a separate division, independent. What do we have at Rosneft these days? And definitely I'm not inviting you to discuss that or moreover criticize it, although this can be discussed. But nonetheless, that's the reality of today. Paradoxically enough, we went back to the symbiosis of the work based on the specificity of the customer and the standardization and unification issue is still in the focus of attention. Well, we need to say that actually nobody was infringing on this work, but at present we're dealing with purchasing, with contracting, and all these elements of work are unified, and they are actually the same in all the divisions. So the present-day model is the model based on a symbiosis of specialized legal specialization, but for every customer. Of course, the customers know their own lawyers, their own counsels who work with them, and the methodological role of the corporate center is very important, and is another important function that we have, and that inevitably will have to be developed in any legal service. It's human resource management and planning, because we keep count of all the costs, of all the labor costs, and we are reporting to business, because optimization of the legal service is not a wish of ours, not just a wish of ours, it's the company need, and it's the need of the business, and the business can quite fairly ask for our reports on economic efficiency, on the number of staff, and so everything that is associated with the cost management should be within the legal service and as part of it. And well, of course, there are performance indicators and planning. These are not legal functions at all, but nonetheless, within the legal department, these functions should exist. And it's a loop. We are not going to go anywhere from this. Legal specialization, basic, fundamental legal education is extremely important, and we are proud of it. Traditionally, we have it, and it's quite good and strong, and this education makes it possible for us to adjust to the realities of today with great ease. And now, allow me to talk about something quite different. Over the past 2 years, we speak about the functionality of the legal division. We are debating the role of counselors in compliance and GR, and in the drawing of and drafting of norms, and we had a panel last year dedicated to that, and it ended with everyone keeping his or her own opinion. So the role of lawyers in corporate governance, so that's another topic for discussion. Is it a legal function? And what is corporate governance in the classical understanding of it? I'm not going to dwell on that, but the reality is such that, Russian reality, is such that corporate management and corporate governance is strongly implemented in the operational management of the company. Many transactions, many decisions go through the process of corporate approval. And with all of that, we understand quite well that assessing risks, we can set out just the regulator's risks. And if we, as for recognizing contracts void, no, there's not that much that we can do. And if they are recognized as void, we cannot do much. Anyway, there is a lot of routine work on corporate approval, on information disclosure, and it's a technical work and technical function. Question? Should the lawyers do it or not? But then there is another aspect of corporate governance, namely the governing of the corporation within the context of operational governance. It's internal drafting of norms, optimization of the company structure. Well, the business and customer are there, of course, but we as lawyers, we can suggest an optimal structural model of the company, considering the legal risks. What is the role of the lawyers, of the counselors in this field? My personal understanding is that corporate governance in the context of law in stock companies is not a legal function. It can exist separately. But everything that is associated with the organizational structure, with the delegation of competences, internal rules and laws and their drafting, description of the business processes and regulation of those, this is not purely legal, but nonetheless it is the sphere of work that is of interest for the lawyers, to the counsels, and the lawyers should be involved in that. And this is the promising trend. And sooner or later it is to become a matter of objective attention and very close attention of the counsels or lawyers in companies. That's what I wanted to share with you. I'm quite sure that there are questions to Igor. Just one question, please. You're welcome. Well, thank you. Thank you, Mikhail Safarov, Euroslex company, law firm. Igor, you spoke about the absence of practical experience and professional experience. Yuri said that your specialists are not related to KPI. In our corporation, the example is different. What is the practice? What is the practice of KPI for those members of your staff who are combining, who are different jobs? Our KPI are divided into the ones that can be counted and the ones that cannot be counted, and we give weight to them on the basis of that. There are some thus which can be easily calculated, and others that are difficult for that. And there are two KPIs. It's judicial efficiency and effectiveness, and you will know that it's advocacy and the number of cases and the losses and the gains, and so it's not the number of cases that we count, but the economic efficiency is important. And second, we the lawyers hold the budget, the total budget for consulting services. So that means that we need to think about saving, which is very sad for our consultants, of course. But although I admire them, of course, and believe that not much can be done without them, but still saving is very important. And again, this is something that we can count, and the consulting budget saving, it's part of our KPI. Everything else is the improvement of the system of corporate governance, and not within the framework of the law on stock companies, but within the system of internal lawmaking, optimization, delegation of competences, optimization of structure, and ownership. And there is another interesting indicator, quite topical for today. It's the efficiency of our work with the public authorities, because we are checked and inspected by different regulators regularly, starting with Rostechnadzor, Rosnedra, and different other services and agencies. And respectively, our main task is to remove the conflict so that it is not taken to the level of the trial. My question is to Dietrich. So, as the head of a legal affairs department of a European law enforcement authority, what is the specifics? And the discussion today, is it topical for you? Is it pertaining to what you are doing within Europol?
Absolutely. Well, it was a very interesting session for me so far, because I came into this session perceiving myself as a strange kind of beast in this illustrious round of in-house counsels, but I've heard many problems and many topics that seem very familiar to me. Okay. So now it is loud and clear. And the lightsaber. May the power be with me. Okay. So it is very valuable. I'm the in-house counsel of a little agency in the middle of nowhere in The Hague, which is called the European Law Enforcement Agency. Maybe you've heard of it. It is mentioned, or it figured prominently in Ocean's 12. We have about 850 staff. 82 million of budget. This is the framework I operate in, so to speak. I myself, I have 40 staff, 12 of them lawyers, and I'm a permanent member of the directorate. So this also indicates what kind of emphasis is put on the advice of the in-house counsel. Now, just to give you a little bit of background information about what we do. Basically, what the European Police Office does is collecting information that is coming from the European police forces, distributes it, analyzes it, and supports investigations. It's a very tightly controlled environment, as you could imagine is the case for every public service. First of all, we have a very closely knitted legal framework that we have to respect. Privacy, so data protection, data security, you name it. But we are also accountable to many different bodies. That starts with the data protection accountability, goes to the financial accountability, and ends with the democratic accountability to the European Parliament, and also the accountability to our stakeholders, which are the member states. So this in itself is an environment which is to a certain extent maybe different from what you're used to. The activities themselves, well, I think they do not sound so different, apart maybe from drafting legislation. And with drafting legislation, I don't mean drafting only the internal rules and procedures. No, this is, for us at least, this is the bigger thing. Just recently we have finalized the drafting session, so to speak, of our founding act. So EU law is something that reinvents itself permanently. It is a very, somebody has once said jokingly that EU law is law on wheels. So it moves constantly, it is a moving target. This also means that assisting in the drafting of legislation is a very challenging process. We also give advice on operational actions, which is the core business of Europol. So there you would have to give advice on how to handle a multinational operation that deals with the investigation of child pornography in, let's say, 20 different jurisdictions. That is quite challenging. We also deal with the normal stuff that all of us in-house counsels do, that is employment law cases. These cases go before a special tribunal of the European Court of Justice. We deal with contracts, commercial law, public procurement, and also with cases which are politically a little bit sensitive. So if, for instance, we have requests from the European Parliament and we have to assess them under a legal and a political perspective, this would be the kind of activity where the legal service also would be involved in. So this is the advice part of the activities. Of course, we also have to manage litigation. Litigation arises mainly in the context of employment law. We have a very litigious in-house population, I must say, but also in the context of commercial law, especially when it comes to procurement procedures. The sexy bit of my work, which also led me here to the wonderful city of St. Petersburg, is our relations with third partners. As one of the very, very few agencies of the big family of European Union agency, we have proper treaty-making power. This is, of course, a wonderful thing. So we can treat proper international agreements with cooperation partners. And amongst them, and this is still under negotiation, is also the Russian Federation. So summing up the particularities and the similarities, I would say I see particularities in what I'm doing in the field of the lawmaking process. The lawmaking process which we can directly influence, or we can directly even legislate internally. Well, not we as a legal service, but we basically prepare the whole act. So this is certainly something which might be different from what you're used to, and also this being the crossroads between legal activities and political activities. And that might be also different from the day-to-day activities that you're used to. Secondly, the similarities. I always see myself as, on the one hand, a consigliere. Some of you might be familiar with the movie The Godfather, which is the Bible for every man. It's the I Ching, the bearer of all wisdom, and you know that, the Godfather, Michael. And you know that the consigliere is the legal advisor of the Godfather. It is the one that knows the business, that sees the legal risks lurking in the shadows, that has to steer the ship legally through the difficult waters between Scylla and Charybdis. But on the other hand, as we are a public organization, there's also the other role, that is the mythological figure of the Cerberus. Although in the Greek mythology, Cerberus was the guardian of the underworld, and I wouldn't consider the law being the underworld of the public service. But still, to a certain extent, you are also the guardian of the law. this inevitably sometimes brings you into conflict. It's the classical conflict between business, because we also make this differentiation between business and support. We consider ourselves as support. The business is the business. So you have to be very careful in using these two different routes. A third similarity might be this old Latin saying, dura lex, sed lex. The law is hard or difficult, but it is the law. So this is a position I sometimes find myself in. If we have very enthusiastic colleagues who want to do something, and I have to tell them, sorry, but this is the law, and there's no way around it. Last slide, because I can see that some of you are a little bit restless, which I can understand. Last slide, where we are and what is coming. I wanted to come back to the topic of the session. I think that our legal world, nationally, supranationally, is getting more and more complex. And now we accept complexity, or we accept the need for technical advice in the context of information technology. IT departments usually always get the staff that they need because the matter is so complex and they use so difficult vocabulary that they basically can do what they want and get away with it and even get more staff. Now, law has the disadvantage that it is accessible to the normal person. On the other hand, it is so complex that you need a specialist. So my perception would be that growing complexity means also that the legal counsel has more responsibility and also more accountability. Companies and also the public service should invest in the in-house counsel, because the counsel is the pathfinder through the legislative jungle. Only the counsel can see the dangers that lurk in the shadow. Only the counsel is spirited enough or has the motivation to prevent the company from running into trouble. Ideally, of course, this is also combined with a sort of political sensitivity for these kind of dangers. So my conclusion would be outsourcing is fine. We do this ourselves. So we have lawyers who are experts in matters or have expertise in matters that we don't have ourselves. So outsourcing is fine, but do invest in a core group of staff that also functionally remains independent. Here I hear with interest that a different model seems to work for Rosneft, which I find good. My personal experience is that if you distribute your legal forces in different departments, you have this classical phenomenon of 2 lawyers, 3 opinions, and the independence of legal advice is often then influenced by the concrete business interests of the department, and the lawyer is then instrumentalized, and they might even fight each other. So it is some sort of forum shopping that you generate with this solution. There are pros and cons. I haven't made a different experience. We have always been an independent little unit, and I certainly do not have the wealth of professional experience of my colleague from Rosneft. Yeah, that in short would be it. I hope that this added a little different or maybe even similar perspective to what you have heard so far. Many thanks for inviting me. And many thanks also to the interpreters. I've listened to them all the time. They're truly excellent, I must say. Thank you.
Большое спасибо.
Thank you, Dietrich. I would ask you to hold your questions until the very end of the session. And now, I would like to ask Ruslan. We've been talking today about the current affairs, the current situation, but what about tomorrow? What are we looking forward to? Well, I hope a good weather, sunshine tomorrow. My burning the midnight oil and the lack of oxygen in this room makes me doubt the fact that I will be able to deliver the entire presentation. So I will ask the moderator and the audience to change the format in a way. I'd like to stand up, if I may. I really cannot continue sitting down. May I use a roving mic instead? Well, first of all, I would like to thank our American colleague, because we can see that he represents a global company, has a global vision. By the way, in Russia, we have a lot of people with ambitions, not only in business, but in politics as well. Hint, hint. I also would like to use the method that Yuliya used today, our moderator. In fact, she gave us a historic background. I'd also like to start from the very beginning, from a recent history. Last year, I spoke at this forum with a presentation on the evolution of the legal function. I promised you to follow up, because there were a number of unanswered questions about the various functions on anti-corruption compliance, anti-monopoly compliance, and I promised that during this session I would tell you what had been done. There were a lot of questions, and I'm showing you the slide. This is the slide that was this last slide of my last year's presentation. You can see the entire evolution of the legal function. We started our company, then along the horizontal axis you can see the various reactive or response measures as well as proactive measures that we took. On the whole, when I finished my presentation last year, I said that the system that we were able to put together in the company, from our point of view, and from the point of view of various observers, is quite efficient. It makes it possible to cut the various regulatory and other risks for the benefit of the company. And now I would like to follow up. I can't even see the slide from this way. So there are three different groups where compliance matters. Obviously, this is a very preliminary breakdown. Compliance is a difficult word, and I use it in the Russian language. Anti-corruption compliance.
And I have to remind you that this function initially, well, in the beginning it was ours, but when we had to implement it, when we had to conduct real inspections, we decided not to interfere with business. Let those who would like to inspect, let them inspect, conduct verification, go to other countries and put obstacles to business. And there is a widespread point of view that anti-corruption compliance should be independent, should report to the board of directors, and we very carefully got it as an independent unit, and now they're reporting to head of our company, and we moved forward. Tax compliance. Well, in the beginning we learned together with our special unit, our tax unit, and in the block of finance and investment, we learned to manage risks quite efficiently, but when at some point we just told ourselves, why are we waiting all the time, accumulate the risks and so on? Maybe we should have prevention, and the system of prevention is highly important, and because the turnover is great, and we have an international company, 5 jurisdictions, we have 450 lawyers, more than you have. And for me, it was a surprise that you don't have, we have more lawyers than Ford. Well, but of course Sberbank is ahead of everybody. And we thought that we needed prevention. And in general, when legal function is in prevention, just as doctors work, the best work is in prevention. And we decided that it would be easier for us to enter the system of horizontal monitoring and relationship with the tax authorities and discuss our main deals and our positions with the tax authorities beforehand. In order to minimize tax control risks. And this is quite different type of work. Nobody was doing it in the country before. Last year only 5 companies had such agreements with the tax authorities, and ours is one of such companies. And I can summarize a lot of things. We are really happy with the results, and we have lower risks. It's quite real. And out of all the transactions, first we choose the most potentially risky transactions. Then we try to discuss them with the tax inspection. We provide online access to our documents for tax inspectors. And this way we lose the right to make a mistake. They see our documents right away. And then we decided that we have to create the system of tax compliance in order to lower the probability of operational risks. And we decided not to take that function. We left it for our tax people, and half of those people have law degrees anyway, and we're just creating some kind of safety net for them, just in case. Anti-monopoly compliance. Why? Because in general, when we're looking at prevention in general in the company, well, it's quite serious. Why so? Because anti-monopoly fines are much greater now because they have turnover fines. When in the beginning, if you take just it's 8% of the whole turnover, of annual turnover, and the fine could be astronomical. And we compared how much money we paid in fines because of anti-monopoly violations before we introduced the practice, and how much we could pay after introduction of that practice. And it's much more, 8-fold, 10-fold. And when we saw that, we realized that we had to do it differently. For us, anti-monopoly risks became key risks, and they're greater than our tax risks. And we decided that if we work so well with tax compliance, we have to work with this anti-monopoly compliance in order to have real prevention of our risks from the very beginning. And today we are at the stage of getting ready for the implementation of this system. This year we're going to get external consultants involved, and if you have some good consultants are present here, well, in the future, law firms, if you're aware of business process of your clients, it's some additional value, because such projects are on the rise now. And we had the best consultants involved, and today, together with them, we create the foundation of the system of anti-monopoly compliance. And so far, we haven't made all the decisions regarding the place of that anti-monopoly compliance, and I hope that we're going to determine it by the end of implementation of the project. But we are ideologists, we're the drivers, we're the sponsors of that process, and I do hope that we're going to keep it. So this is something that had last year. And now, what's going to happen tomorrow? And I would put it the following way. We are not using our imagination. We are looking at expectations. What is expected of our business. And I'm going to tell you more later, but now I can tell you that there are certain expectations of the lawyers regarding business, and based on previous practice, we must evolve. And the previous presentation was called Evolution of the Legal Function 1.0. Now it's 2.0 evolution. In order to be logical, I would start with the basics. So, what is the value of the legal function? What's our difference from consulting lawyers? What kind of competition is there when you hire in-house counsels compared with law firms? Sometimes in-house, well, they get more money. Sometimes law firms pay more. We compete. What can we give lawyers so that we're attractive to them? And the answer is very simple. We give extra opportunity to participate in creation of value of business that we work in. This is our main difference. How do we create this value? Influence or management of risks, and this is the foundation of our legal strategy. And actually we are risk managers, all of us. And of course risk management is in discovering the risks, and if we have this opportunity, we prevent the risks, or we abolish the risks if it works. If not, we get the company adapted to those risks. And if we didn't adapt the company well, so we're dealing with the consequences of existing risks. So that's claims work, court work, and so on. So there are 4 directions of our risk management function. And those risks, managing those risks, we must understand that the risks may be different. Internal, also industry risks, also country risks. And all that is determined in the formula of value of the company. The lower the risks, the higher the value of the company, and the lower are our risks. The more work we do, higher is so the value is greater. Now, of course, you have to follow lots of other conditions. This is just the ratio. This is our place, how we influence the value through risk management and creation of opportunities. What are the risks I'm talking about? Once again, I have to repeat internal, industry, and country risks. And last presentation, I mentioned just corporate risks and industry risks, and we promoted our function so that it could be dealing with management of those risks. Recently, we encountered new challenges, and the legal function, when we are talking about where it's going, what it should be. This is not the matter of taste. This is not the matter of ambitions. This is objective reality. And we started thinking, what's going on? What's wrong? Inside the company, our processes are working. We are regulating the activities that influence of our telecommunications business. Some people do it better, some people do it worse, but somehow we learned to manage those risks. And in this slide, I distributed So internal corporate risks, also industry risks and country risks. And I show how we had these risks the bottom, corporate risks, less and less, because we all learned to manage those risks. And the new risks, well, they do emerge, but not so often. The work is organized. More industry risks, even when you look at the quantity, and somehow we manage to deal with those. And if we are not capable of doing it, so we are getting ready. Country risks. Well, the first country risks, well, it happened in Kyrgyzstan when we lost our asset even before we purchased it. That was the country risk. That was the harbinger. And then was very quiet. Starting 2010, every 2 years, we have country risks. And if you look at those triangles, those risks are more and more tangible. But what's painted there are the peak periods, the crisis, because the country risks create crisis for the company, crisis because you risk losing your asset, which is much more important than solving some problem or having the project. This is something the business loses. And we learn, statistically, we can see that we encounter those risks more and more often. Now let's ask ourselves a question. Are we ready? Are we ready as lawyers, as in-house counsel? And I have to tell you, about 8 years ago, I ceased to exist as an external consultant, but even at that time, I realized that major companies, they worked so well, but when everything was quiet. But as soon as some crisis emerges, people don't know who is going to do what, and the lawyers become just those people on the forefront who are going to deal with everything. And it leads to the situation that, yes, there are some political resources and so on, but you have to deal with that on a regular basis. And lawyers are the ones who are going to do it. And immediately when the company is in the zone of risks, the whole management, well, the restructuring is happening and some other things happen. The same regarding lawyers. We can see that at some point risks are getting greater. And we're talking here about the quality and quantity of those risks. Are we ready or not ready? Let's not think about whose function it is, but we must be, as soldiers of the company, we must be there on the forefront, and we must provide this first line of defense. And the board of directors always invite the lawyers, and the operational activities, well, it becomes everything becomes secondary. Even in our business in India, it was all the same. It's not specified here. Nevertheless, we had the same conditions.
First, Uzbekistan, Ukraine. And I can say that a few days ago, the Council of National Defense actually raised the question of withdrawing our license. Just imagine, anything can happen. Well, we managed, but for the next half year, we don't know what happens next. So who should deal with that? I don't know, indeed, but it happens that we are responsible for that. We are doing that. So it's not theory that we should talk about. I'm just describing the real situation. Some might have a similar situation. Things can be very different. Anyway, I would like to say that as the Chinese say, the crisis is not a problem, but it's also a new opportunity. And here is on the next slide, you can see the evolution of the 0-2 function. Crisis is a significant and often unforeseeable change that can damage the organization and the interested parties. A company can overcome crisis both with losses and with advantages gained. It has always been like that. And respectively, any crisis is restructuring within the company, and the lawyers, the counsels, should provide the gentle transition to this new period. Overcoming crisis. So this triangle, this pyramid, if we look deep into it, we will see classical legal functions in many of the companies we come across, and corporate governance is there as well, and it should be there. Indeed, I haven't mentioned all the functions, but from the bottom to top, we can see the evolution. First, any legal function is a service function, dealing with operational tasks. With time, there appears a need to deal with new requirements. It's necessary to examine the new markets, particularly if they are non-traditional, if they are difficult markets. It's necessary to join the analytical function, forecasting how business is going to develop at the next stage, under what legal conditions it's going to develop. So David said, well, the cars without drivers. The lawyers are thinking, well, we have a similar situation. Our sphere is quite innovative, and we know within our company quite a lot that is not known to the public at large, because we are analyzing all of that, but there is no legal basis for that, and that means we come across new risks. How can we manage them? Working at the for the mass sector, we have to analyze everything. Everything has to be carefully considered, and these should be people who are just summing up everything, generalizing, and not managing anything. At the top of this pyramid, I can display here the anti-crisis maintenance, and this is what we come across. I don't know whether this is weighting everyone, but we are coming across this. So there is a new function emerging, new opportunities through overcoming of the crisis and difficulties. So what is there to think of next? We must think of who is going to carry out this work. Who are these people? What qualities, what capacities and abilities they should possess? And using the division of risks into company risks and country risks, and I decided to demonstrate the evolution of the competences. The question was asked today, and whom do you need? Well, I think that if the work in the company is built in such a way that the lawyers just work on the inner risks, internal risks, then of course we need to have a very high level of professionalism and the deep knowledge of technologies and techniques in the company. This is an overall requirement for all companies. If within the company the work is built on the basis of the management of sectoral risks, then after 8 years of work in the company, I have seen it all, and this is my personal experience. I'm not trying to teach anyone, I'm just describing my own experience. So it's business ethics, first of all, in this case, orientation at business, and complex expert examination. You can see that it's right at the edge between the corporate risks and country risks. It's the integrated expert examination of different consequences, the behavior of counteragents, regulators, controllers, and so on and so forth. So we need expert examination as such. We have been saying that for quite a while. There is no need for us to hear from you, you shouldn't do this or that. We understand all of this. So it's at the edge. And when we are saying that It's the next stage, the stage of the country risk management that we're dealing with now. The country risks have an impact on the company. A company might lose business. And we do not have any skills in that field. We do not have people, a human resource, and I think there are leaders' qualities needed first of all, because the crisis calls up the leaders, and the quiet and peaceful times leaders are not that much needed, but when there is a crisis, leaders are in need. If a company is ambitious, if the company wants to work in other countries, then leaders are needed, not necessarily the CEOs of the company. Well, at a certain period of time, these leaders can be hibernating, but we should start looking for these leaders around us, trying to understand who are these people who can take the responsibility upon themselves for decision making and who can involve the rest of our staff into the active process of crisis overcoming. Of course, there are other countries with different legal systems and different cultures. We can see that. And if we are managing the country risks, then of course our lawyers must be politically literate, so to speak. Our counselors, our lawyers, should read a lot, should understand what is happening in the countries and what the processes are, what are the moving forces in this or that country. So they need to be properly orientated. And so these challenges bring about these requirements, the evolution of the functions and the competences. The next question we come across is as follows. How can we build this team? How can we have this very special team built? Because now we are facing a challenge as well. The top managers of the company have this problem. Otherwise, if you do not have this team, you either fall or you are to be fired. So that's one of the challenges our profession is facing today. And it's a need to find leaders in the team and retain the leaders at different levels in the regions or elsewhere. It's a difficult task, I believe. It's a managerial task. But it's there, it's with us, it's inevitable. We have to deal it. We have two instruments here we can deal with, tangible and intangible motivation. Tangible is quite clear, material motivation. Intangible, that's different. In our company, we decided last year that the overall program of intangible motivation designed by our human resource department is not good enough for the lawyers, for the counsels. So we began to ask people, what makes you stay in the company? What, particularly regional lawyers who have less opportunities for further development. In almost 100% cases, people say, I want to get new knowledge, new experience. I would like to capitalize myself because I want to be a full-fledged, independent no matter where I am, at what particular level I work. And this makes lawyers different from many other people of other professions in a company. That's why training is very important. That's why we need to invite stars from the market for our people to meet them. It's particularly important for the regional lawyers. They are most grateful for that, and this is an incentive for them and another form of motivation. There are programs that help to reveal the best and provide them practical training opportunities, and we organized a contest among lawyers at different levels in the regions, in the corporate center. Every quarter we announce a competition, and there is a program of incentives and awards, and for some it's money, for others internship training. A young lawyer from Ufa recently was able to join Vodafone. It's one of the global operators and our strategic partner. He spent a week with them and he came back greatly impressed, telling the stories, this is intangible motivation. It's the most important for the lawyers. It's the recognition program. And rounding up and completing my story, I would like to say that in the near future, and I'm proceeding here from the challenges that we're facing, and then expectations of the management. By the way, last time we said that we're managing risks and we're creating opportunities. Beginning with the first year, I finally have KPI nobody else used to have. Usually KPI in business are divided into with business, creation of opportunities, with lawyers, the risk management, and KPI is based on that. For the first time this year, I have a KPI which covers risk management and KPI associated with opportunities creation. And that's exactly what business expects from us. They want us to expect them, they expect us to help them to develop new services through new conditions, regulatory conditions, through different legal methods, because business needs development, because otherwise the competition is too high and they might fall. And the top managers are trying to understand what they can extract, so to speak, from the legal departments. They understand how to create the competitive advantages. So the topic of leadership and the search for leaders, that's our future. And moreover, we need to look for them, find them, and make them busy at the time between crises. So again, intangible motivation works here better than material motivation. Occur can be the legal forum can be just the right place for us to continue this discussion. I have come to the end of my presentation, but well, allow me to have 3 extra minutes. Concluding, well, a few words concerning our about our conference. It's with the Constitutional Court together, where we try to trace the trends and understand what's happening in our field. Yesterday, we were discussing the amendments of the Civil Code and the consequences. And the discussion we had today makes me think that our evolution, the evolution of our function, depends not only on the expectations of the business, but also on the state of the system of law in the country. Our civil code, which is being amended, contains many notions in about 300 articles that actually provide us the necessary ground for assessment and for evaluation.
And these notions were quasi-legal because they come from the moral side of the business. We're talking about business. What are the notions that are important in business? Efficiency, cost efficiency, profits. And it turns out that this is yet another challenge which proceeds from the changes to the civil code. This is something that we will face very soon. We will have to change the business processes as well as the overall mentality within the company to make sure that our businesses follow the moral values. I don't think that anything like that had happened before, at least not in this country. I don't think this has been tried before, and this is yet another challenge. It shows that our profession is a truly interesting profession. It's a truly exciting business. Thank you very much, Ruslan. Well, we have 2 options now. We can take 2 questions to Ruslan and Dietrich and other speakers, or we can just finish now, thank our speakers, and then continue informally outside this room. I suppose that we can stay for a while and just talk informally. Do we take 2 questions or do we just close the discussions? Okay, informal discussions. Well, thank you very much. Thank you to all the speakers. Thank you to all who came to listen to them. Thank you. We would be very grateful if you found time to fill in our questionnaires. Thank you.